There's a great irony that the first reference to President Kennedy came not from Mr. Kerry, but from our European friend here.
I wanted to hear the Boston accent, though. That would have been great.
Mariella, did you want to?
Sure. You want me to go next? Yeah. Absolutely. Happy to. And I just want to say thank you. This is really a very interesting and important conversation, and I want to thank everyone for being here. I had just a couple of thoughts based off of the following comments. The interesting question is Frank said, the U.S. government may know the EU citizens better than the European Union member states do. I'm not necessarily so sure about that, because one of the things that's interesting in having the umbrella conversation, and also just generally in my role as the DHS privacy officer, to get to know the European system, one of the big things that you guys use from law enforcement perspective is wiretaps, which we can't use except in very specific circumstances. But in Europe, the number of wiretaps is literally thousands of times more than in the U.S. side, which is a way to get to know your citizens pretty well. And it's a fair point, because we talk about these kind of fundamental rights, but what I try to do in my job every day is, what does that mean in application? In principle, we've got these principles, but how does that work in application every day? And what's the enforceability of rights? That's one of the things that Mr. Hasbrook talked about. And what are the how are they enforced and how are they not enforced? For example, many of you probably know that when you go to the European Union, your information, if you stay in a hotel, is likely transferred to the police for some reason, right? We're not 100% sure. We're not 100% sure how long they keep it, depending on the member state. But I think that's something I'd want to know and probably would want to hear about. And I guess, who do you go to ask that information about? Who do you ask to access your information and to see if you can correct it in that circumstance? And I think it's worthwhile. Frank talked a little bit about transparency. It is something that I like to talk about a lot, and I really think that CFP is a really important dialogue, because it is about transparency, and it is about making sure we're doing the right thing, and it is about having the conversations to, Edward asked for, grassroots in the European Union. Well, you guys already are here, and for that we really appreciate it. But I think that the U.S. actually leads on transparency in terms of what we do and what we don't do, and how we disclose information, our privacy impact assessments, and the system of records notices, and the comments that you guys provide. And I'm wrapping up, aren't I? Okay, so anyways, I think that we've got to learn a lot that we can learn on both sides. The end, Barry.
Thank you, Jan.
Yeah, thank you. I just want to get further a little bit on my comments. I think, you heard from Frank Schmiede that we are obviously also working on our own data analyzing systems and so on, and that's exactly what I said. I have a political position, political standpoint inside Europe, and I guess this is a debate which we have on both sides of the Atlantic at the same time. And I think we would be stupid if we just let some Europeans do the work on privacy and civil liberties also, because it's a thing we have to do on both sides of the Atlantic now. And I can see that at the moment the Europeans are also going in the direction of measures which the US, for example, took up since 9/11. And there's one very important point, which is exactly what Edward mentioned also, and that is the difference between the classical law enforcement and information sharing agreements which are based on analyzing and using information and data of suspects, known suspects, and the new form of investigating with an electronic analyzing way, using blanket retention data. And of course, using this data, also doing profiling and so on, is something which police ever did. But I think there's a huge difference between looking face to face to a police officer, seeing the police officer, being examined by him, and having the possibility to also afterwards ask for redress or information about all these processes, and on the other side, being analyzed without knowing about this or without having this present by a black box, by a computerized system, and afterwards a policeman just takes the result and judges me or treats me on the basis of such results. I think that has to do with foreseeability, and foreseeability is for a legitimate a government and an institution and for democracy a fundamental principle. And that's why I really think that we have to talk about all these techniques which we are using and about the vast amount of data which we are analyzing for law enforcement purposes.
Thank you very much, John. And Edward?
We've heard a lot of discussion about data protection, but I think it's really important to understand that the fundamental rights at stake in this discussion are not only, and I would argue not primarily, data protection rights. And that's one of the reasons why it's essential, and why the European Parliament said in the PNR context it's essential to get the ICCPR into this debate. It's part of the terms of reference. Data are used, and there are data protection rules about how the data are protected from disclosure and so forth. But also, data is used, data transferred on this agreement will be used in ways that will impact people's fundamental rights. It will be used to make decisions about whether or not to let them on a plane, whether or not to let them transfer money, whether or not to subject them to a variety of other consequences. And it's essential that we recognize that there are other fundamental rights implicated by the decisions that will be made in whole or in part on the basis of this data. Thus far, as I understand it, the US side has been willing only to talk about saying we won't make certain kinds of decisions solely on the basis of this data, as though the slightest human rubber stamping of a robotic decision was sufficient to justify it. That's not good enough to satisfy due process or fundamental rights standards, and we need to recognize both the data protection rights and the other rights implicated by whatever decisions are made to any degree on the basis of this kind of data.
For the questions and answers in a moment. We're hopeful first to be able to see the clip from Vice President Redding, but I was going to suggest actually that since you need to leave at 10:20, I have a question that I was going to pose to you, but why don't you go ahead and then I'll pose it.
Ladies and gentlemen,
Oh, she's talking. I'm done.
the United States and the European Union have a long-standing cooperation in the field of justice and home affairs. Information sharing is essential to fight crime, but when combating terrorism, we must not forget our citizens' rights. These rights must be protected, also when it concerns the gathering of personal information for security purposes. The US and the EU are now negotiating a data protection agreement for law enforcement purposes. Our privacy systems are not identical, and we are trying to overcome gaps and discrepancies. We try to set up a solid common standard. We try to secure data exchanges over the Atlantic. For the European Commission, it is crucial that we can agree not only to share personal data, but also to protect such data. Also for our Parliament, a comprehensive data protection agreement with legally binding data protection standards and enforceable rights of citizens is essential for any transatlantic data sharing. Since the end of March, our negotiators have held positive and constructive talks on a number of complex issues. The negotiations are not easy, precisely because the matters at stake are closely linked to the constitutional and legal order of both sides. But I'm confident that we will find ways to ensure coherence and legal certainty. We can build on our well-established cooperation to achieve a real step forward in protecting the personal data of American and European citizens. Today's conference is a good opportunity to discuss privacy and data protection issues in the Internet area. I appreciate your interest very much. The US-EU agreement is in the hands of policymakers, of course, but specialists, practitioners, technologists, academics and businesses who are all present at today's conference have an important role in supporting internet diplomacy and fundamental rights. I wish all of you a very successful conference and very fruitful debates.
I do want to give you an opportunity to make your point. Then, if you could hold on for 1 minute beyond that, I'd like to ask Justin.
Yeah, no, that's fine. I'll go to like 10:23 for you, Barry.
All right.
The only point I wanted to make was one I forgot, but both John, Philipp, and Ed did, which is it is the United States' intent to have the umbrella agreement cover both case-specific sharing, case-by-case sharing, as well as more comprehensive program-based sharing. That's all.
Okay. So we're going to move to the question and answer period,
Sure.
But I was going to take the moderator's prerogative here and ask the first question. First for you, Mary Ellen, then I ask that our European friends here also take a crack at this, which is I know one of the concerns that I've heard from Europeans about this agreement and about the transatlantic exchange of data in general is a concern that once data is transferred from Europe to the United States, that once it gets to the hands of the United States government, that there are insufficient protections for the onward transfer of that data, either to other elements of the United States government or to the private sector. And I'm wondering if you could address that.
Yep, thanks, Barry. And that is a comment I've heard on my trips to Europe, and one that I don't think is appropriately placed. As we all know, the United States has specific reasons and specific authorities in how it collects information, how it uses information, and what those uses are. And there's a kind of myth in the United States, or in the EU, that there's one big database, right? And that I think even Edward kind of alluded to it, that the U.S. government gets Google data and we also give data to Google, right? Neither of those things happen, let me be very clear. But with that said, the system of records notices, the disclosures, the ability to, under Department of Homeland Security mixed systems policy, to ask where your information is and how it's being used, are all protections, including, of course, routine uses under system of records notices. And we take those responsibilities quite seriously, and in fact, I go and confirm that indeed the statements made in our public statements, such as SORNs and PIAs, are indeed accurate. And so the fear that this is just become one big database is unfounded.
Frank, I'm going to ask the European government officials to respond first, and then Edward will give you a shot. Anything you want to add to that, Jan?